This is a CBS News special report. I'm Charlie Rose with Nora O'Donnell in New York. The Supreme Court has just issued a ruling in a case challenging part of a historic voting rights law.
The lawsuit focuses on the federal government's power to review any change in voting procedures. It applies to 16 states where there's a history of discrimination against minority voters. Jan Crawford is outside the Supreme Court with the decision. Jan, good morning. How did they rule?
Good morning, Nora, and good morning, Charlie. The justices have just released this decision, of course, written by Chief Justice John Roberts. A conservative majority, 5-4, very divided court has ruled that a provision of that key 1965 landmark law no longer is constitutional. What this means is those states that are covered, they're mostly in the South, right now are not going to have to get this pre-approval before they make changes in their voting requirements. The court has said that Congress has to come back and take another look at this law. They're invalidating a provision that determines which states are covered. That formula, the court said, is out of date. Congress hasn't revised it since the 70s, and the court said that's not fair. Things have changed. We now have moral racial disparity, indicating that the South is not all that different anymore than the North. So what they're doing here is sending this case to Congress and saying, take another look at this formula if you want to hold these states to these burdens that they have to get approval from the Justice Department before they make these changes in their voting requirements. Now, this, of course, was a significant major law when Congress passed it back in 1965, considered essential to guaranteeing access to the polls by minorities who, of course, had been shut out from voting and from running for office. Today, though, the court says that was 50 years ago, and now it's time for Congress to decide to sit down and take a hard look at whether things have changed and whether those old formulas Congress was still relying on as recently as 2006, when it reauthorized this provision, today are still valid. So this puts the ball back in Congress's court, but there's a reason Congress hasn't updated this provision since the 1970s. It's not going to be so easy for Congress to decide what to do now. And that's why some people will say, and you're going to hear, that this almost may be fatal, in fact, to these pre-clearance provisions. Let me make a point, though. The court could have issued a much broader ruling. It could have said the Justice Department no longer has any role in approving these kind of changes in voting. The court did not say that. It took a slightly more narrow approach and said, we're going to let Congress take a look at this. Now, Justice Ginsburg has written a scathing dissent for the liberal justices, saying essentially that the court is ignoring history. The court is ignoring history in this case and really taking the court to task for invalidating this provision of the Voting Rights Act and sending it back to Congress. Justice Thomas, considered the court's most conservative member, while of course Justice Ginsburg is considered the most liberal, is writing also a separate opinion today. He's suggesting the court should have just gone ahead and gone further and said that this provision no longer was necessary. That's not what the court ruled. They're sending it back to Congress, but again, it's going to be difficult for Congress to come up with an answer to this.